for your participation. We're going to start this meeting right now, I guess. I welcome everybody to the Lapeer Tea Party. This is a special meeting, and it is basically a panel discussion. Our agenda, we're not going to have welcome slides, I assume. No welcome slides. All right, so we'll have to, we'll go right into the opening prayer with Carol.
Thank you. Please stand with me for the prayer. Father, we are grateful to be able to gather together and openly and freely discuss the principles of our nation's laws, along with the implementation and enforcement of them. May everything said tonight be truthful and bring greater understanding to us. In Jesus' name, amen.
Amen. All right, everybody stand and let's do the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mike, I used your flag.
Perfect. Not quite in unison. All right, ladies and gentlemen, the Lapeer Tea Party has been digesting for a whole year now political forms and issues of controversy. We thought it was an advisable thing based upon the climate that we have a discussion about the entire year. What has transpired here, what is the cause and effect, and we have a nice panel of participants, and we have a nice panel. Everybody's free and welcome to jive in here. But I do know that I will introduce our panel that have Zoomed in. This is Court of Appeals Judge Brock Swartzle. I believe you're in Lansing, correct, Brock?
Okemos,
just north of Lansing. And then we have the Patriot Week co-founder, founder, Judge Michael Warren from Oakland Circuit Court. There he is. And then we have honored guests here, and we have those who have, apparently there's some confusion about my invitation, but those who have responded are on the panel. That is Judge Byron Konschuh. He's our sitting Lapeer County Circuit Court, 40th Circuit Court. Then we have our prosecuting attorney, Mike Sharkey, and we have our Lapeer County Sheriff, Scott McKenna. Scott is the one I broached first on this issue, and he was all in favor of it, and I thought it was an important issue. Now, before I turn the discussion directly over to Brock Swartzle, who wanted to address the First Amendment issue, because this is the First Amendment, I just wanted to briefly summarize and review what has transpired here. We normally would have a slide. We are going to cover the First Amendment, Second Amendment, Fourth Amendment, Fifth, 8th, 4th, and 15th. Now, listen, there's no way we're going to cover this thoroughly, but these are the issues that we think are the issues of the day. We started with the culmination of the presidential impeachment, December of 19 through January. We then had the onset of the COVID-19 pandemic. We then had the governor's emergency executive orders. We had quarantine, social distancing, wearing a mask, and then we had the imposition of normal, natural hygiene behavior. All right? We then went to the social unrest, which resulted from systematic shutdowns and closures and quarantines impressed by these emergency orders, and then the release, gradual relaxation, all sorts of chaos all over the country. All right? Then we had the destruction of monuments and artifacts. Then we had the most recent adjudication ruling these procedures, the emergency orders implemented under the 1945 Michigan legislation ruled unconstitutional. I have that decision, and Brock Swartzle was kind enough to forward that to me. Then we had the chaos in the voting processes during the presidential election cycle. the recent judicial ruling mandating reinforcement of casting and counting ballots not later than November 3rd. That was a recent decision as of Thursday last week. Prior to that, we had the death of Supreme Court Justice Ruth Bader Ginsburg. All right, and then we've got the confirmation process ongoing. This has all caused chaos throughout the country, one way or another. Then we have the new CDC orders mandating certain individuals' restrictions. That's implemented today, or not today, but it seems to be implemented, and there's some confusion on that. I'd like to see whether we can address whether or not that is a mandatory function, whether we're ruling under the 1976 law, we don't know. Okay? We've got still the imposition of social distancing, group gathering restrictions, closures of businesses. All right? Then we have the most recent terrorist attempt, internal domestic terrorist attempt, a coup against the governor of the state of Michigan. All right? You got 14 individuals locked up between a cooperative venture between the local governmental officials and the FBI. And then we have the most recent thing that has caused further chaos, is the press censorship by social media moguls, Twitter and Facebook, on the relevance of certain stories pertaining to one of the presidential candidates. All right? We don't know what the theory is, what the problem is, but we have censorship on that issue, and the facts are not being fully disclosed, or they're being disclosed only through certain channels. So that is the laundry list of what we have today. I am a sort of a student of history, and I reflect on certain things. And one of the things that's interesting to me, I always bring up the certain authors and writers of certain periods of time. I always reflect on Victor Hugo. Okay? Why do I bring him up? He wrote this fascinating book called The Hunchback of Notre Dame. We still refer to Victor Hugo in our modern musicals, Les Miserables, and so forth. Now, why is he important? He's important because in the 1830s was the start of what we call republicanism. If you study history, the French were studying this, and they studied our Constitution and our writers, Madison, Adams, and Jefferson, back when we formed this country. And it was republicanism. And he wrote this beautiful, fascinating story about the Hunchback of Notre Dame. What did he deal with? He dealt with issues of trial by crime and punishment, not by ordeal. Crime and punishment. He dealt with church and state issues, sanctuary, the separation of the church and the seeking of sanctuary for crimes for somebody who was being persecuted. All right? He dealt with the exploration of grievances to the government. Through what process? Through writing and petitions. It was a historical novel, and it was the formation of writing. Okay? We have all these issues dealing with the First Amendment, the Second Amendment, and the Fourth Amendment, search and seizure, and all these issues. So I'm bringing all this to your attention, and I tell you folks, we are revisiting history, and when we have people in our culture saying we shouldn't revisit our history, we should abolish our history, we are doing the wrong things. So I thought it was important for an educational and informational format that we bring all these parties together to discuss these rather fascinating articles on our amendment. And I will now turn this podium over to Brock. Judge Swartzle, we're going to start off with the First Amendment, and you had requested that you wanted to address that discussion, and you may start, and the issues that I faxed you was basically the summarization: religion, rights to religion, speech and press, assembly, and the redressing of grievances. And I also would point out that we have censorship, and we have the issue of the Supreme Court decision of New York Times versus Sullivan. So I'd like you to maybe introduce or discuss a little bit your concerns of what's going on in the climate today. Wait a second, Brock. Make sure he's... Go ahead. We're not hearing you. You've got to be unmuted, right?
I'm
Okay, there you go.
unmuted. You can hear me?
Yeah.
Okay. Well, first I want to say thank you for the invitation to speak this evening. And I also appreciate, Maurice, you understanding that I have to pop off around 7:30 for another event. I wanted to open up with just two very brief remarks before I get to the First Amendment. One, I think it kind of goes along with your rendition of 2020 thus far, Maurice. My minister this weekend told a story about how God and the angel Gabriel were meeting to kind of discuss things and just talk about the itinerary and, you know, get kind of caught up. And God said, okay, well, you know, Gabriel, you know, I told you to lay out a list of chaos events for the 2020s, you know, let's go through those. And Gabriel started and he said, wait a minute, you said 2020s? And God said, yeah. And he said, I thought you said 2020. And God said, so you put a decade's worth of chaos events in 1 year? It's amazing when you go through that list. We started off the year with impeachment, and nobody's talking about impeachment. You know, there's 1,000 other things that have happened since then. It's amazing. And again, you know, we're going to talk briefly about the First Amendment, but the opinion that came out a couple of weeks that I sent you, Maurice, that was based purely on separation of powers. And I think, you know, it's good that we talk about the specific rights that are enumerated in the Bill of Rights. But I think it's even more important to remember that our Constitution, the framework built into the Constitution, is maybe more important than the Bill of Rights themselves. And I know Justice Scalia felt that it was the separation of powers and all the mechanisms put into the Constitution that were the most important guarantees for liberty and freedom over the long run. With that said, the Bill of Rights is obviously crucial, and you know, I think I can speak for hopefully everyone in the room to say we're really glad that we have a Bill of Rights. The First Amendment is critical. It has 5 components, and Maurice, you indicated, you know, we've got the free speech, we've got the petition, assembly. Those are kind of the citizens' interactions with its government. And then you have the free exercise and establishment clauses that deal more specifically with religion. And I teach government relations at Michigan State School of Law. And I tell them, you know, it's a First Amendment class. And most people don't think about government relations and lobbying and such as a First Amendment issue. But I make it clear. I said, you know, petitioning the government, lobbying the government, being a constituent, interacting with your local representative or your senator, that's all built into the First Amendment. And so it's crucial that we have those protections. And so, you know, I'm happy to talk about those. One thing that I really, what was brought home to me when I worked in the legislature, and the one branch that seems to get beat up repeatedly over the years is the legislature, whether it's our state legislature or Congress. You know, you take polls and people just despise Congress. It despises the legislature. Oftentimes loves their congressman or congresswoman, loves the local representative, but as an institution, it usually ranks, you know, right there at the bottom with all other or with any other institution that's reviled. But frankly, it's the institution that's closest to the people. It should be the institution that we embrace the most as citizens, because when I was working in the legislature, we would get constituent outreach requests, you know, concerns. Each representative would get 5 or 10 a day. The Speaker's office would probably get 40 or 50. We had a whole department. It was constituent relations. It was completely, their job was to help constituents and answer their questions and point them maybe into the right direction. And so there was an instance where you had these constituents who were exercising their First Amendment rights to petition the government. And the legislature, at least on the Republican side, we took it very seriously, very seriously. And so I think if there's any institution that people should get behind, citizens should support, run for office, go down to Lansing and meet with your representative, it's really the legislature. I don't want to speak for Judge Warren, but in the judiciary, we don't really interact with constituents. We have cases, and we interact with parties, and we interact with lawyers, and we interact with members of the State Bar of Michigan or some local bar or whatever. That's how we interact with citizens for the most part. The executive branch, the departments will interact with citizens, but that's usually a very unpleasant interaction. So I hope that over the next days, weeks, years, that we get a renewed respect for our legislature and kind of the centrality that it plays in our government. You indicated, or you talked a little bit about censorship. We have censorship. There's the official kind, which are newspapers not running certain ads or certain. Let me back up. If it's a private company, Facebook, it's a question of whether it is true censorship. It's not illegal censorship for the most part, unless they're found to be a monopolist or something. They're a private entity. They can publish what they want. The problem is that social media has taken on such an outsized role in our society as of the last 4 or 5 years, that it really is getting to the point of almost official censorship. It's not there yet, because again, these are still private bodies. They're not regulated entities, like a utility or something. And I think courts and the governments and the legislatures are going to struggle over the next few years on how you ensure that all voices are heard on social media, but you respect the fact that they're private companies. So I think there's a balance that we need to draw. And frankly, over the coming years, if an antitrust lawsuit is brought, some of these companies, some of these social media companies, might start be treated as a regulated entity in some way. I've kind of blathered on for a little bit. I'm happy to turn it over to Judge Warren or anybody else, or if you have questions, I'm happy to answer them.
Anybody in the crowd have any questions on the First Amendment issues that Judge Brox has addressed? All right. I am curious if you are a member of this social media group and you're using it as a source of information to distribute your thoughts as an individual, and there's no real particular contract between the user who endorses membership to such a group and then publishes and declares certain statements through the media source, how can the source, the body itself, edit the personal posting? Seems to be a pattern in practice where they either edit it, censor it, or remove it from your post. What's your thoughts on that?
Well, let's take Facebook as the example. I don't have Twitter. Twitter, I think, is where things just instantly go crazy. But I have Facebook. I have a personal Facebook account. I also have a campaign Facebook account. And, Facebook's a little bit different in that we're bound, as a user, I'm bound by their rules and regulations. Their rules of service. They're a private entity. They're a publicly traded company, but they're owned by shareholders. And so, to the extent that I cross one of their rules, then that's on me. Now, if they break their own rules, then we have a problem. Maybe there's a lawsuit there, or at least maybe there's an avenue to get some redress. So if they're violating their own rules, or if their rules are so vague that they're written in such a way to intentionally kind of trick people, then there may be some legal redress. But again, you know, as of right now, they're a private entity. They're not regulated as a public utility, and so, you know, we still live in a land of private property, and for the most part, if you own private property, if you own stock in a company, you should be able to run that company. The problem really is the fact that these, you know, a few social media companies have become so powerful in terms of communications and getting the voice out. You know, 20, 30, 40 years ago, we all had a really robust hometown newspaper. I grew up in Battle Creek. The Battle Creek Inquirer was our newspaper, but we also had one or two other smaller papers. But then you had the Kalamazoo Gazette, you had the Jackson papers, and if you didn't like the Battle Creek Inquirer, you'd go to the Jackson paper, you'd go to the Kalamazoo paper, you'd go to Athens or Union City. I mean, you had competition. In our system now, we don't have nearly as much competition in media as we used to, I don't think. You know, we've got some big newspapers, Wall Street Journal, New York Times are doing okay. Detroit News, Free Press are kind of doing okay. But in terms of local news, those have just been decimated. They're a shell of their former self. And, you know, now you've got Facebook, Twitter trying to fill the void of local news, and that's usually not very good, frankly. I think it's pretty bad. So we're running up against the fact that these private companies who we would normally want to allow to operate the way they see fit to maximize profits for their shareholders, we're running into the problem that they are approaching monopoly power, possibly. And so you may start having some antitrust issues. I did antitrust work for a few years when I was in private practice. I don't know that we're there yet. We might be there with Google. I saw that the federal government filed a lawsuit today. But private antitrust really needs to be very selectively used because it can be definitely abused. It was abused by people on the left back in the 60s and 70s. It was horrible. So I'm not suggesting we open up the antitrust Pandora's box, but we do need to kind of look at, okay, our Facebook, Google, Twitter, Amazon, are they getting to the point where, you know, society needs to regulate their usage? And that's a broad discussion that we're going to have, I think, over the next few years.
Well, the follow-up to the issue then would become the so-called mass media outlets broadcast on the major network stations, who seem to have a persuasive power in one direction and not giving fair coverage to the opposite side. So we have President Trump on one side, so representing the right, and we have the leftist viewpoint, which seems to be most of the mass media, which is not disclosing all of the evidence, all facts or information on reports. So the question becomes, is that a form of censorship that needs to be addressed? Is that a restriction on the freedom of press and the freedom of speech or access? And is it a sort of a governmental organizational takeover, not a governmental, but some kind of takeover that is more persuasive and not giving the public the full information that's necessary? How do we address those issues?
Well, you just raised a bunch of issues there, Maurice.
Yeah.
So let's focus on a couple. One, I think it's incumbent upon each and every person to support the media outlets that seem to be doing a pretty good job. Nobody's going to be perfect. There's always going, you know, it's human institutions. We're always going to fall short from perfection in one way or another. But, you know, certain organizations do a much better job of approaching the perfection, you know, doing their level best, being objective, putting out all sides. And I think it's incumbent upon us to support them with money. You know, I'm a Wall Street Journal subscriber. I subscribe to the Detroit News because I think of the Michigan papers, the Detroit News is probably certainly better than the Free Press. I subscribe to Crane's newspaper. I've got several other, National Review, Reason Magazine. We have to pay these companies, or, we're going to get what we pay for. If you don't pay anything, you're going to get junk. And so, and in terms of the broadcast news, NBC, CBS, I'll be honest, I just don't watch. I don't get my news through TV. So I can't really speak to, I have the sense that Fox News is further to the right, while CNN, MSNBC, the rest are kind of to the left. But I only get that because people, I see people complaining about it on Facebook. I don't get my news from those organizations because frankly, they're so shallow, and there's, you don't get a very in-depth discussion with a 20-second soundbite. I'd much rather read a newspaper. I'd much rather, just read something a little bit more deeper and more thoughtful. And so, my suggestion would be to everyone in this room, just stop watching the networks. Just get your news from places that you pay for, and you'll get what you pay for. In terms of censorship, the broadcast news, they are regulated. They were given the airwaves by the government, and so they have to follow certain practices, but those practices are pretty lax. Whether it's censorship or whether it's just, kind of groupthink, may turn out to be the same thing. But again, I think that there are alternative sources for us to get our news, and we should encourage those and pay for the good ones. Support a local newspaper, support the Detroit News, because if they're getting money, they're going to do a better job. That's kind of my view.
All right. Any other questions from the audience? Anybody want to ask a question of the judge? How about Judge Warren? Do you want to chime in on this issue, or Judge Warren?
Sure, I'd be happy to. I know that Judge Swartzle's got to leave, so I won't take offense if he disappears while I'm talking. First off, I want to thank everyone, too. I really appreciate the opportunity to address you again, and hopefully we can keep this up. Maurice, thank you for your diligence in connection with this and being accommodating in connection with the Zoom call. I know it's not the same as having people in person, and I appreciate that, and hopefully we'll be there soon in person. A couple of just tidbits, and then I'll launch into some broader comments. If you hate Google, like I do, don't use it. I use DuckDuckGo on my phone, and sometimes I use Google on some of my other devices. But if you want privacy, you don't want to be tracked, you don't want to fund them and monetize them, there are alternatives. I understand that the federal government believes there might be a monopoly because they have so much of the share of the market, but there are these other services. So I would, and DuckDuckGo doesn't cost any money, and it, as far as I can tell, it's not quite as good as Google as the search engine, but the payoff there is the privacy and the other things. I also pay for the Detroit News. I used to get a hard copy paper. I've given that up, but I think the advice of supporting establishments that support good, unbiased approaches is appropriate. I'm a big podcast person, so I listen to the Heritage Foundation has the Daily Signal. I also listen to Up First, which is NPR, because I want to know what the other side is thinking. And I even listen to some even further radical, because I want to hear their perspective. So, but going in, NPR is the voice of establishment Democrat or progressive politics, and they're not going to be very kind to Judge Barrett in their confirmation, for example. So, look at a variety of sources. I also agree with Justice Scalia and Judge Swartzle that much of our protections and freedoms are protected by not the Bill of Rights, but by the structural protections that we have. And I would include in that, although it's almost been totally gutted, the idea of enumerated powers. That is that the federal government only has powers that are expressly provided for in the Constitution. That was seen as a huge protection for liberty, and that we divide power up not just between the branches, but that we also divide it between the state governments and the federal government. And that tension is very healthy. It's very important to protect liberty. It's not just about having laboratories of democracy, which is from a famous, but I consider it an infamous footnote that a Supreme Court justice wrote that said, we have federalism so that we can have experimentation. No, we have federalism to protect liberty. You also get the benefit of the laboratories of democracy, but that's not the purpose of it. It's not just so that we can have some experiments and then have Washington, D.C. impose one best solution upon everybody. It's the exact opposite. Reserved to the federal government are very expressed powers. If it's outside of that power, the federal government shouldn't do it. It should be reserved for the state government. State government has broad authority to do anything it wants unless there's a specific thing that stops it. The federal government's the other way around. It can't do anything unless there's a specific provision in the Constitution that allows it. And so we've lost much of that understanding in the last generation, and I think that has led us down the path that we find ourselves today. I'm going to highlight religious liberty because I think that is under-cherished, and we really need to put that up on the top of our agenda. America was founded by a number of colonists and colonies for a variety of reasons, but one of the major ones was to flee religious intolerance in Europe and to establish a beacon of liberty, religious freedom in America.
Judge Warren?
Yep.
I don't mean to break in. I agree with everything you've said, and I'm going to anticipate that I am going to agree with everything you're going to say. But I do have to jump down. I have to jump on another one. Again, I appreciate your time, and Judge Warren, continue on.
Thank you. Have a great night.
Thank you.
Judge Brock, Judge Swartzle, thank you very much.
So we've oh, look, I'm much bigger now. Okay, so we have this. We were established as a beacon of freedom in the world from religious intolerance. It's a mixed record because when we started, what ended up happening was some of those that were fleeing persecution ended up becoming persecutors. But over time, there really were havens of religious freedom that did not exist anywhere else in the world. And then we adopted as a fundamental right, the free exercise of religion, driven mostly by Madison, along with support from Jefferson. And then we disestablished churches. So we used to have churches that our tax dollars would support, and then the churches would take that money and then evangelize that particular denomination's religion. And so if you were a Catholic, but the religious institution in the state was Anglican, they would take your money and give it to people that basically condemned your religion, right? It was a terrible thing. And Madison and Jefferson teamed up to disestablish the church in Virginia, and that spread across the country and then became the basis of the first two protections in the First Amendment. Most people think of free speech and free press, but really the first one is the free exercise of religion. The second is that no government, there will be no government established church. It was originally against the federal government, later on became applicable to the state governments. As Madison, he had a very famous speech called a Memorial Remonstrance Against Religious Assessments. And he posited that your first duty before government is to your God, and that you needed to be free to worship your God the way that you thought was necessary to save your soul, and that if a government tried to stop you from doing that, that it was infringing on the most important unalienable right that you could have. And unalienable rights come from God, not from the government, and they can't be taken away. So that was when Madison wrote the First Amendment, he put free exercise of religion first, and then put in the Establishment Clause second, and then he got to the others. And that's really an understanding that I think has come under tremendous assault in the last generation or two, that people do not appreciate freedom of religion. They take it for granted, or they don't think it's important. Our society has become more secular over time, so there's less religious people, so they see it less important. And so you see this clash where the government is trying to impose duties on people that violate their religion. It's like the cake shop case where, you know, the individual said, "I'll sell you a cake. I'll sell you a cake with frosting on it. I'm just not going to write a certain phrase that you want me to write on the cake because that violates my religious freedom. You're telling me that I have to celebrate this marriage that I don't believe in." And thankfully, the Supreme Court found in favor of that person. But we see that all over. Part of that has happened because, I'm sorry, I'm just kind of wandering stream of consciousness here, but you should know that before the 1990s, we had a very high test of scrutiny against government impositions on the free exercise of religion. We call that the strict scrutiny test. So if the government wants to infringe on your beliefs, or first off, they can't infringe on your beliefs at all, but if they want to infringe on your actions, they have to have a compelling reason to do that, a compelling state interest, and the means to that interest, to further that interest, have to be narrowly tailored. So that's what's called strict scrutiny. And for example, let's say there's a satanic cult out there, and they say, well, you know, baby sacrifice is part of our religion, so we're going to go sacrifice babies. And we would say, no. We have a compelling state interest in protecting life of innocent babies, and we are going to outlaw sacrifices of children. Can't do it any more narrowly than that, and so that would survive a strict scrutiny test. But in the 1990s, there was a case in which, unfortunately written by one of my judicial heroes, Antonin Scalia, and he wrote, if it's a general law, if it's a general law of applicability, in other words, it applies to everybody, that you just need what we call rational basis test. So it just has to be a recognized government interest, and it has to be reasonably related. It doesn't have to be this narrow test. And so a lot of freedoms were under, a lot of religious freedoms were under assault. And then, of all people, Bill Clinton joined up with the Congress and passed what's called the Religious Freedom Restoration Act, which reasserted the strict scrutiny. But then the Supreme Court said, you can only do that for the federal government. You can't do that for the states. So then a number of states have passed their own version of the Freedom Restoration Act, and that includes Michigan. So we thankfully have a protection in Michigan, but it's by law, not by our Constitution. And so, you know, this whole culture war out there where religion is really being denigrated, where religious beliefs of people are being mocked and taunted and overridden by, you know, the fads of the day, is very, very serious concern. And I think that, you know, it wouldn't take much to have, you know, a new government. Well, if the Michigan legislature were to flip, not necessarily partisan, because I'm trying not to be partisan, but from people that didn't care about freedom of religion and cared more about other things, they could repeal that law, and then they could pass all kinds of laws that would infringe the religious freedoms and liberties of our citizens. So that's something to be very cognizant of when you're exercising the vote and assessing candidates. You know, people that believe in religious freedom and protecting it through that law, and supporting judges who believe in protecting the liberties of individuals from the kind of the fads of the day and protecting religious liberty. or is it something that, someone that has a different perspective?
Well,
So I'll stop there on the First Amendment. I know I've talked a lot.
Well, I do want to follow up on one issue. The issue of the day is being tested right now regarding the appointment of the Supreme Court Justice, Amy Barrett. And her beliefs has been brought to the attention of the public because there's opposition by the Democrats indicating that her beliefs and her religious freedoms imposes a problem for her appointment on the bench because it contravenes with a lot of other beliefs such as abortion and female rights and so forth. So it is a significant issue of the day that's being addressed as we speak, is it not?
You lost me at that last second. I'm sorry. What was the specific question?
This is an issue that's being addressed with the nomination and appointment process of Amy Coney Barrett with regard to her beliefs, her strict Catholic beliefs, and her beliefs in which is.
I'm sorry. Is the question that you want me to respond to whether or not that's right?
Yeah.
That her beliefs are under attack?
Yeah.
Yeah. Well, when she was up for her initial appointment to the Court of Appeals for the federal bench, that clearly was true. I mean, Feinstein was, the infamous quote, "The dogma lives strongly in you," and those things really did come out quite a bit. I listened to, I didn't get to watch because, I'm busy on the bench, but I did get to view a fair portion of the Barrett proceedings this go around. And I would say I didn't see that, I didn't hear those words. I think they were very careful, and maybe there was pieces of it I missed. But I think generally they were pretty careful not to fall into that trap. The Democrat, I was going to call them the inquisitors, but that's not fair. The Democrat questioners. Yeah. But I think there was a subcurrent that they were very concerned that her, whether it's religious or conservative beliefs or political beliefs, whatever it is, that would bleed into her judicial decision-making, and that would render results that they disagree with. And that was obvious. I mean, it was, no question about it. I didn't hear them go after her saying, well, you're Catholic. They were much more subtle this way. Biden's Catholic, so that's, that you're a conservative Catholic, you actually believe in the doctrine of the church. It seemed like there were some trial balloons that were floated a couple weeks before. Once it was announced, they started doing these trial balloons. And one was, well, she's a dogmatic Catholic. Another is, oh, she's an imperialist because she's adopted black kids from, another country. And she's and then the argument, oh, she's got 7 kids, so how she could possibly have time to succeed? These very insulting kind of ad hominem attacks. And so I think when those trial balloons were crashing, that they backed away from those. So all I heard were, again, I didn't hear everything, but I heard compliments about her family and how beautiful they were and how she's a great mother. But you've got this bad judicial view. That's what I heard mostly. But the subtext clearly is different.
All right, I think I'm going to broaden this discussion now, and I'm going to ask our panel members to step up. And John, you are invited to join this panel. I have no problem. I thought I invited you, and I apologize publicly if you didn't misconstrued. I thought I emailed you and asked anybody, including Judge Barnard, to participate. But I did give you an invitation, did I not, Judge? Really? I am sorry, because I thought that was an open invitation to anybody who received it. But there's a chair. Now here's the discussion that I'd like to
I'm sorry. I only see the symbol of the Tea Party, I don't know if that's on purpose, but I can't, for a time period, I could see you actually talking with your microphone and your great bow tie. There we go. All right, thank you. Now I can see you guys.
All right, now you won't be able to see these panel members unless the cameras. We have John Miller is our incoming prosecutor. Mike Sharkey is our sitting prosecutor. Scott McKenna is our Macomb, yeah, Lapeer County Sheriff, and then Judge Byron Konschuh is our sitting circuit court judge. I'm going to continue on with the Second Amendment, First Amendment, go into the Second Amendment, and there's two issues I want that's all-encompassing with regard to the society today. One is the right to assemble and peacefully gather and petition for redress or grievances, and what we call the peaceful, what the president is calling now the peaceful protest, okay? Because otherwise, according to the emergency orders that we had, that was not permitted. So these are all encompassed under the First Amendment. We have the Second Amendment, which is the, the symbolic and important right to bear arms and the formation of militia. So what I'd like the panel to discuss, and we can go left to right, I don't mind. We can even start with, well, actually, I think I'd like to start with our law enforcement officer. And we don't have much of a difficulty in Lapeer, and we don't want any difficulty in Lapeer, but the right to assemble and protest and do whatever we need to do, what's happening out there? So give us a sort of a brief glimpse of what's happening in our culture today.
So I think you kind of mentioned it, we don't have a lot of these problems over here. And I say, obviously, on a lot of these topics, I'm probably the last one that should answer some of these things. We've had a couple of protests. A lot of them had to do with what they believe is social injustice on the law enforcement side. Truthfully, those protests were run well. They were very peaceful. We had no issues with it. We are one of the, I'd say with all the law enforcement side, we kind of approached them from the beginning. We wanted to be at the front of it. So for those kind of things, we really haven't had a lot of the issues in there. The big thing for me personally, or for the law enforcement side, is the right to bear arms. That's the big topic that, truthfully, coming off of this weekend, has been, I couldn't even tell you how many phone calls I've got, and a lot of it came from the AG's statement, from the Secretary of State, on the open carry side, on Election Day. So we've dealt with so many topics, and I think, and obviously the judges mentioned it at the beginning, sometimes when I look at these things, you think that this was over a 20-year career, and it's really been over about 9 months that we've been dealing with every one of these issues. So I swear I wake up tomorrow morning and there's a new phone call about a new topic somewhere that we're dealing with. Obviously, we had earlier, where Lapeer County, we ended up doing the Sanctuary County because of the Second Amendment stuff, took a strong stance on that. We're blessed in this county with those items. The one part I touch on that with the new statement coming out from the AG reference the open carry. Everybody knows in this room that when we had the executive orders, I spoke out and said we would not be enforcing them. I disagreed with them. Obviously, we see the end result of that is why. We're going down the exact same path again, truthfully, is what's happening here. They are now coming out with orders, and if you look at what we received on Friday from the Attorney General, reference that you could not open carry within polling locations within the state, but obviously within our county. That came out from our Secretary of State. The AG, Dana Nessel, put this out stating that that was to be enforced, and that was supposed to be enforced by us. She then responded in the Detroit News the next day saying if the sheriffs didn't uphold it, that the state police would uphold that. So with that part of it, and so in digging, and obviously more of the judges and prosecutors' MOs, I pulled the Attorney General's, where was she getting her basis on this? Where does the Secretary of State, where do you get the authority to show me a law out there that says you can't open carry? Now there's some parts of that I might not agree with certain things on it, but show me the law where you're unable to carry.
I think Judge Warren wants to, did you want to interject here, Judge?
I was just stretching. No, I'm okay.
Oh, okay. Then I'm going to ask our sheriff this question. We have the incoming prosecutor and we have the sitting prosecutor. Do you confer with either one of these gentlemen right now as to the issue of what's transpiring? And I will point out to everybody in this room, it was my understanding that there was a federal lawsuit started, I believe, on Friday in the federal district court in Grand Rapids regarding this issue. Okay, you are aware of that?
That's true.
Okay, so.
Yes, so yes, we all talk about it, and obviously Michigan Sheriff's Association, all the sheriffs in the state, has been nonstop this weekend with it. And so we pulled even with legal counsel in Lansing and obviously amongst us locally, is to look and see where are you getting that, where are you basing that authority from? The way the Attorney General is saying, it basically comes from, and it's MCL 162.21 is what she states, and 162.31. Those are election law things. There has zero to do with open carry with it. So again, we're going down the same path of where we throw multiple things to confuse and try to put that out there. But there's no lawful, there's no statute, there's no law that prohibits it. So for our stance with it is, we have to separate a little bit. Is one, for the open carry side of in Lapeer County, we will not be enforcing that. From the side of voter intimidation, that we would be enforcing. That we could have to have zero tolerance on.
What happens if the state police, by the way, the state police was invited to this forum, and I hope they didn't get the same confusion that I gave everybody else, but, and they have not, they obviously didn't show. So I'm curious whether or not you coordinate activity with the state police regarding.
Good question. So this morning I met with all the clerks in the county, from all of the townships and with Teresa Spencer. Teresa does a fantastic job with coordinating all these things. The problem is you just created so much confusion for each one of these townships, each one of these polls, that didn't need to happen. Basically what you did is you threw on a gasoline on a fire that didn't exist. And especially in our county, you got good people, and to be honest with you, open carry is not uncommon in Lapeer County. I mean, everyone's used to that or understands it. So, but you really threw the clerks under the bus. So we met with a lot of them. The state police had contacted Ms. Spencer about a week and a half ago, asking if they had any issues at any of the polls locally that they needed addressed with it. And obviously, we all the elected officials work very closely together, and she said that no, she was good with it. When I found out yesterday that they had contacted him, I called the trooper that's kind of handling our region for that part. And to be honest with you, I put him right on the spot, and it was probably not fair to him because he's a trooper and he's not up the part of it. But I said, I want you to give me an answer. I want you to know, because your question is going to be, okay, you're not enforcing it at the sheriff's department, but if the state police comes in, somebody open carries, are they going to arrest them? Are they going to charge him under whatever fictitious law we've created in this park? So he couldn't answer that to me. I know personally how they feel about it locally. They're in a tough bind. She's really, especially with the comment in the Detroit News, saying that if the sheriffs don't do it, the state police is going to.
Right.
You talk about throwing them under the bus, and I truly feel bad for the state police in the positions they went into. So I don't have an answer for that. That's something you're going to run up the ladder to Lansing. But also, you do have the existing side from the legislature that this lawsuit has been filed. I hear a lot out of Lansing believing that they're going to push it through so that we have an answer prior to election day.
Well, okay. See, we're now in the reverse situation of a city like Portland, where we have this kind of conflict, whereas Portland has a situation where they don't support their police whatsoever. So we have a directive from the governor indicating to the state police, enforce this law, we back you on this, and we have our local sheriff's department, and then we have our prosecutors here, incoming and outgoing. Mike, what's your position on the situation with the Second Amendment? Now, I just want to preface one other thing and comment about how supportive Scott is to our Tea Party. We started back in February. We did the forum here in the Lapeer Tea Party for the Second Amendment, and it was well attended, and then chaos hit because of COVID. But that was a symbolic issue, and not more symbolic as to the reaffirmation of our Constitution. But we also sent a letter and a resolution from the county to the governor's office indicating that this is our position in Lapeer County. And for further clarification, I sent an invitation to Chief Craig in Detroit because I wanted a different perspective in an urban environment with a population of 660,000, how you deal with that. And yet I know that he is a supporter of the Second Amendment, and he also supports, I believe, open carry. So these are issues, urban environment, rural environment, and we have a different, and I wanted to give a different perspective. So, Mike, how about, what's your feeling on what's happening?
Can you hear me? Does that work?
Is it on? Mike is a soft-spoken individual.
Okay, very good. Well, we've raised the issue first with the separation of powers doctrine, freedom of speech, we've got freedom of religion, we have Second Amendment issues, and once you hand the microphone to a lawyer and you start talking about the Constitution, it's hard to let anybody get a word in otherwise here. I'm keenly aware of what's happening with at the state level. We have 83 separate counties, 83 separate sheriffs, 83 separate prosecuting attorneys. And we look to our Attorney General for direction and guidance, so there is some consistency here on the treatment of issues relative to enforcement of the law. Consistency, I think, is credence to credibility. We have the Sheriff's Association, and they were certainly outspoken against the enforcement of the executive orders for that the governor issued. That went through the court process, the trial level, the appellate level, and then finally to the Supreme Court. And the Supreme Court made the decision, a 4-3 decision, to say that the executive orders were not constitutional. That makes the job of the prosecutor, who has to give advice to law enforcement agencies. We have 7 law enforcement agencies in the county, and the sheriff and the state police and the city of Lapeer being the principal ones. They need clear direction about what the law says. So you have flip-flop decisions all the way up through the appellate level, with the final word being a divided opinion. And as a lawyer, you don't like to see that as good precedence when you have a divided decision. It looks like we're going to be proceeding down that same path as it relates to the issue of open carry at the polls. I haven't talked too technical yet with the chiefs of police, although we're planning on having a meeting to deal with this issue. And that relates to the enforceability of effectively an executive order by the Secretary of State. So the question that should be instinctual for an attorney, particularly a prosecutor, because we're going to anticipate field questions, is what's the legal authority? And so like the sheriff says, and I like it when he talks about the law, because sometimes he's got it right, and he's got it right at a very at a street level where he communicates and people understand. Lawyers talk sometimes and they're not as clear. But the legal issue regarding the authority of the Secretary of State is not based on a statute, it's based on an administrative instruction. So the legal issue that will be tested is whether or not an administrative instruction is sufficient to be enforced as as proper legal authority, particularly when it has to be relied on when police officers may be making arrests, police officers may be presenting a request to the prosecuting attorney's office, and the prosecuting attorney is going to say, well, what's the legal authority? So to sum it up, I think what we're going to see is a fact-based issue. We'll have to see, and the sheriff is right, there is a distinction between open carry and voter intimidation. And if there is intimidation, I suspect that we may be receiving some sort of review or request or an actual arrest. And we'll have to deal with that, and we'll see how this goes. I'm anxious to give some clear directive, and I guess the best place to start is here at a forum like this. So thank you for inviting me. And if I haven't run off the clock, I need to head up and make this.
Well, I'm going to have your successor address this issue. But before we go, John, let me just say something. A very, very important issue for everybody in the audience. You heard Judge Swartzle. He is a candidate for the Justice of the Michigan Supreme Court. Now, what's important about Justice Swartzle is he's a very staunch conservative. He also represented the Republican Party in Lansing on these issues. He is a professor while he's sitting as a judge doing these activities. And it is very, very important for this constitutional decision that I have here that we're talking about. It's right here. On the constitutional aspects of the governor's actions being ruled unconstitutional. There was a unanimous consensus among all the justices that she overreached her powers, particularly as to the time frame. But the decision was a consensus, like you say, 4-3. And if we lose Judge Martin, who rendered the decision, and we do not replace Judge Martin with a conservative judge, we will have a shift on this Supreme Court of Michigan, which could turn the tide very dramatically against certain activities that we think we value as our Bill of Rights. Now, John, I'm going to have you address some of these issues because you are in the fray and you're going to be addressing these issues soon.
Thank you.
Did it go off?
It went off.
You know, these precedent. There you go.
Should be on now. Thank you. Thank you for having me here tonight. I think it's a very fundamental issue. And a very wise man who I have an immense amount of respect for once said, the most dangerous words in the English language are, I'm from the government, I'm here to help. If anybody, here's some captains in the audience, if you know your history, you know that was Ronald Reagan's words. I think that any time you have a single branch of government declaring that their word is the gospel, that they are there to tell you what to do and what to think and how to act, I think that's a very dangerous situation. I had no doubt in my mind that the governor's executive orders were unconstitutional, in my own mind, when those were declared back in March. There's not an instance in government that withholds our Constitution that can ever prevail that puts forth the tenet that a single branch of government can dictate what law is and what penalty is without the voice of the people. That's what the governor's executive orders did back in March. They circumvented that, those orders circumvented the legislature, they circumvented the people, and I think they were, in my opinion, unconstitutional right from the get-go. So I was happy that the court actually, the Michigan Supreme Court, found and confirmed that. However, if you're a student of the law, you would also know that that was a footnote in a federal case that doesn't actually have controlling jurisdiction here in Michigan. It's a complexity in the law, how that decision came forward, because it came as a result of a federal district court lawsuit. So without trying to lose everybody in the fray here of legal jargon, I just want to make it very clear that the court basically got it right. I think the court basically got it right. But whenever there's this situation that government speaks for the people without a vote of the legislature and imposes a penalty on its own, you got to be thinking unconstitutional right out of your heads. I mean, we've all had government from grade school. We all understand that you don't need a law degree to comprehend that notion. Secondly, as it relates to the Second Amendment, I believe in the Second Amendment. I believe in the right to bear arms. I think that the interest of the public in balancing the interest of a right to bear arms versus a right to show up at a poll with an open carry is a delicate situation, right? Because what you're implying with that scenario is that an individual can walk in with his AR-15 over his shoulder and go to the poll and vote. And the implication is that these other people that show up without arms are going to feel somehow minimized or mitigated or intimidated by this individual showing up there. I don't think we can tolerate that. I mean, you know, you can't show up with you can't show up at a precinct to vote with a vote for Trump or a vote for Biden T-shirt on and go in and expect to vote. That's a long-standing rule. The right to vote has to be impartial. It cannot be clouded by some sphere of intimidation, I don't think. But at the same time, without a law directly on point that's been passed by the legislature and signed by the governor, it says you can't bear an arm at a precinct. We have a situation. I think the sheriff spoke to that situation aptly by saying that enforcement is going to be a problem there. If there's an enforcement issue where someone is there causing a scene and causing intimidation, that person should be removed from that, because everybody in this room and everybody out in the public has a right to show up at that precinct and vote without being intimidated or harassed about their presence in being there or their mindset in voting. That's fundamental to our Constitution, I believe. So with that said, if there's any questions and follow-up to what I've remarked to, I'd be happy to answer those, but I'm rather succinct on the point, I hope. Thank you.
That's one issue. I sort of have a follow-up to that. You would then coordinate your activity with your law enforcement officer and say, look, we have a situation. If you got a call from Scott and he was questioning what he should do, what would you direct him in a situation based upon the facts where somebody does present an AK-47? Scott, well, let me start with Scott. Scott, you're on the scene. Somebody's got an AK-47 slung over the shoulder. What would you do?
Well, the directives going out to all the deputies are going to be simple with the situation we have, and I agree with what John said too of that. There's a really fine line here, and that's the part where we're going to describe to people, if you can show me, and I encourage anybody to do so, if you can show me a law that stops you from doing that, then present that to me, as into the open carry. There is none. And there isn't at that point. We're walking a real fine line, kind of like we did with the executive orders. If I enforce those, or am I then putting not only the county, but the municipality, everybody at risk by doing that, by getting sued, because there is no lawful MCL statute, whatever it may be, that are through them. The biggest part of that is the separation of the two, voter intimidation.
Right.
Here, with the enforcement of the open carry, again, show me the lawful side of it is, and I probably don't need that. I'm too loud as it is.
Well, I think we're going to pick up on the mic.
Oh, gotcha. But they have to be separated. Voter intimidation is a whole new area. Now, we got a lot of gray in the middle of that. But like Mike and John both said, I have zero tolerance for voter intimidation. If you're coming there with open carry, walking in, and you're intimidating people as you're going through there, and the problem is it puts a really tough situation for these poll workers to be in, and that's who I feel for, and even with the clerks today. But we're going to be told, or the deputies will be told with it, if there is voter intimidation, that's cut and dry. We have laws on that. We have statutes that cover that to where we can charge that. But then you're saying to enforce this open carry side of it is, and show me under what statute that we're supposed to enforce that. So it's two separate issues, I guess is the way I'd say it.
Hold on, we have a question from the audience.
My question is, based on this law, it's not tied to any legislation or legal, I mean, there's really no law tied to it. This law is based on interpretation. Now, Maurice walks into a polling place and sees somebody that has something strapped to their hip. Maybe he grew up, maybe he was a victim of crime. And he feels intimidated. He can't vote. I walk in, it's a big deal. I grew up on a farm. What's the matter? So, based on this, how do you slide the interpretation from one person's maybe weaker side to another person's power? I mean, where is this? Is just that's not, doesn't seem like a very fine line to do.
I do believe you're correct. That's a good segue into the judge making a determination. Let's say, well, the judge has got we got a case in controversy. Let's say the state police, let's say you don't determine it's intimidation, but the state police comes in and enforces the governor's rule. It's now brought before the circuit court on this crime, and we're sitting here before a judge and a bench for a preliminary examination, and you're conducting this hearing.
Well, thank you for inviting me tonight. I don't know if this is on.
You better push that power and keep going off.
Sounded on.
There's a power. Right.
All right, and thank you for giving me a question that's impossible for me to answer. As a sitting judge, I can't tell you how I'm going to rule in a situation, but the difficulty is when you look at these situations, many of them are in the gray area. There is no good answer. It's on a case-by-case basis, and you have to look for, is there any overt threatening? Is it subtle threatening? And like you said, there's a subjective situation, a subjective component to that as to how an individual feels when someone else walks in with a gun, and is that, unless there's some kind of overt action or some statement, it's hard to say that there's any intimidation going on.
It just seems like a moving threshold.
Right, it's impossible for me to say what's going to happen. I mean, on the extreme side, where someone walks in with a gun and points it at somebody and threatens them, there you go. So on the other extreme, if somebody has a gun in a holster and it's open carry, and you walk up and you vote and you don't have any contact with anybody, so to speak, you're fine. It's an in-between that's going to cause the problem, and I understand that, and if there's especially no legislation on point, it's hard to follow that. And so again, thank you for the impossible question.
Well, here's the issue. I guess this one's not working, so we're going to share this. This edict from the Secretary of State is not based upon the law. It's an administrative agency determination, right? Lawyers in the crowd?
It's called an instruction.
It's an instruction.
Instruction, directive, these are synonymous terms.
So the question becomes, and I'll ask the judge, how enforceable is that when it comes before you?
Well, the circuit judge is going to be a challenge, and regardless of how I rule, it's more than likely going up to the Court of Appeals to determine whether it's a valid law
or administrative agency determination. Judge
Warren has
Judge
anything
Warren?
to add to that.
And you've heard that. Can I give you the impossible question? If you have an administrative instruction, okay, you can get another one. Here. We got microphones being passed all over the place. So I'm going to give you the impossible question. We have an administrative agency determination from the executive branch of government instructing us that this needs to be enforced. Is it enforceable or not? Yeah.
All right, so there's some possibility that this kind of case will show up before me. So I will not give a straight-up answer, because you're not supposed to do that, as we've learned from Judge Barrett over the last few days. But I would say that it posits a very interesting question about the authority of an administrative agency pitted against the Constitution. For what it's worth, I don't have any problem stating out loud that I believe that the Heller decision finding that Second Amendment right to bear arms is an individual right, that is the law of the land. I think it was correctly decided. So remember before I was discussing the levels of scrutiny. As a fundamental right, there's a high level of scrutiny that's applied to attempts to infringe on the right to bear arms, but it's not absolute, obviously. When I render a sentence finding someone, when I take a plea or there's a guilty verdict in a felony case, they're not able to own a firearm anymore. Maybe that will become a case someday. That was one of the cases that Judge Barrett was addressing. But it's a great law school test exam question, and who knows? Who knows? The judge said that it would go up to the Court of Appeals. That could go straight up to the U.S. Supreme Court. I mean, by the time you get through all the levels, I wouldn't be shocked if that kind of case makes it to the U.S. Supreme Court, because you're pitting those competing interests. It would be very interesting to see.
All right. Thank you for, yeah.
Let me make some quick comments.
Yeah.
Is this working?
Just press that button.
It's working.
Is this power?
It was working.
Yep, it's working.
Bill, you raise a real good question here. And what the sheriff and what a prosecutor will eventually have to work out is whether or not these are facts sufficient to support a criminal charge of intimidation. And what the evaluation process takes into consideration is supposed to be what we call standards in the law. And you used the example of you being unoffended by somebody carrying an AR rifle. Somebody else would be very intimidated. But the law isn't based on the two ends of the spectrum. The law is based on what we call a reasonable man standard. So your example, I would say that's the squeamish person standard. May very well be offended, and I don't have a label for your standard here. You're just not offended. You're just Bill. But, so you'd have to evaluate it from that perspective. And he's the unreasonable man. So hopefully we won't have any issues here. And we are in a rural community where the environment is we've all grown up with guns. So, but not everybody. So. That's how it would be evaluated, and if it ever gets to a court of law, those would be arguments. Now, the Secretary of State has an argument here. It's just not one that falls into the realm that we're used to when we look to statutory authority for enforcement. But there are broader arguments that can be made, and creative lawyers can come up with those, so that's why you have divided cases or divided decisions and eventually a resolution ultimately by the Supreme Court.
Just for the record, I totally understand what you guys are saying. In my particular issue, I don't like, to me, I don't like laws that are applied unevenly, or, the law should be the law today, tomorrow, yesterday, the exact same standard for everybody. And this type of, kind of saw the same thing with the governor's orders. Some of her orders, some of her things, common sense, I could agree with some stuff. But just the premise for the legal side, that's my only issue. So I'm not trying to put anybody on the spot.
No, and Bill, I think we're all on the same page with it. That's why law enforcement, to be honest with you, this year with the executive orders, that's why everyone's so frustrated. Is because truthfully, it was every day us reading through these, trying to figure and determine them. And the problem is you'd have multiple sides come in and interpreting it 2 different ways, or 3 different ways, or 8 different ways. And then the next morning we had another executive order that we're trying to fill out. A lot of them affected our jails, our schools, our businesses, and a lot of times we're the source that people are calling with it. That's what's so frustrating about it. This has been a really rough year for the law enforcement side on multiple sides, because ultimately we're going to confer when the report comes down. And then obviously they're going to make the decision based on law. the deputies, the officers and things like that, they're on scene, which you know better than anybody, are on scene trying to make a determination on what is intimidation, especially when there's no definitive answer of what that definition actually is. So that's where it's been so tough this year, because we try to get it. And I think when you see like Michigan Sheriff's Association, the MACP, the chiefs of police and stuff, that's why we were screaming so loud, because a lot of those, one of the biggest things that we asked through there, and I'm not here just to sit and bash Lansing, but we asked repeatedly for seats at the table during these decisions, because we were finding out when the public did. I promise you, and I probably told you this or seen this, when the press conferences came out, when she did her press conferences, I sat through every single one of them, because things were changing so quickly with it. When I would sit at my desk, after calls with her, that multiple sheriffs would be on with her, as that press conference was going, you'd be 10 minutes into it, and I'd be sitting at my desk, and about 15 to 20 seconds prior to what she said was going to be the new change, my email would go off. So they would hold it to go out to the sheriffs 15, 20 seconds prior to the public hearing it. So then we'd sit back and say, okay, and then our phone started ringing when we just found out when we did, or when they did. That's the hard part. And a lot of it, like you said, is interpretation, but a lot of these guys and gals are on scene trying to figure it out, and a lot of that is then compiling the information, investigating like they would do normally, and then ultimately it would go to the prosecutor for them to determine.
Just to clarify also, because our organization has been in touch with the representatives, the state representatives, I can assure you that you weren't as frustrated as much as the legislature was for a period of 7.5 months until this decision came out, because they had no access to talk to the governor would not even talk to the legislative branch of government. She would just make an edict, which is why we see all these signs, dictator and this, that, and the other. So now that that's rectified in the sense that there's actually been some movement between the legislature. They worked till 3:30 in the morning just 2 nights ago to deal with these COVID situations and budgeting prospects and refurbishing the businesses. So the frustration went to the issue of delegation of authority and the fundamental challenge to the Constitution. So I'm glad the decision came down, and we're going to have more edicts on this issue. Which brings us to another topic, which is the Fourth Amendment. And the reason the Fourth Amendment is so interesting right now, I'm going to go right to a segue, because right on the ballot, the language on the ballot, which I have here someplace, proposition, it's called Proposal 20, wait a second, I better pull this out. Judge Warren, I'm in the position you are, and I'm going to have to pull these out. Here we go. Proposition 2020-2, a proposed constitutional amendment to require a search warrant in order to access a person's electronic data or electronic communications. Now, this is on the ballot. Rather than read the language, you're going to read the language. It's basically reinforcing the constitutional mandates of the Fourth Amendment warrant requirements for these electronic conveyances. Now, we've had issues, again, we talked about impeachment at the beginning of the year. What was the impeachment based upon? An improper execution of the Fourth Amendment FISA warrants, which came up with false data and information. The Fourth Amendment was not properly processed. There was no oath and affirmation. It was perjured testimony that furthered a complaint against the chief law enforcement of the United States official, which came to an impeachment issue. I was totally offended by this because I'm a Fourth Amendment guy, and it's extending. Now, the question I have for you, all of the panel members, and this is this is not a case in controversy. We can go right down the line. I'm going to start with John. John, are you in favor of that proposition? Is this working?
You have me on there? Sounds like it. So the Fourth Amendment, in my mind, is fairly straightforward, right? It represents the notion that people have a reasonable expectation to privacy in places that they have a privacy to maintain those interests, right? So when it comes to issues surrounding the Fourth Amendment, I firmly believe that the Fourth Amendment is there to protect our constitutional rights. And I think it's even more prevalent now than it ever has been in history. We had heard Judge Swartzle, we heard Judge Warren, we heard these comments about what's going on with Google, what's going on with Facebook, what's going on with all of these search engines and all of this social media and all of the abundance of technology that surrounds every single one of us. Maybe I'm not the only one in the audience, but when I get in my car at 5 or 5:30 in the evening to go home, my phone tells me I have a 27-minute drive to get to my home. Now, how does my phone know that? Because I didn't tell it to do that. So if you don't think for a minute that you have a reasonable expectation of privacy to these types of things going on in your everyday life, I'm here to tell you you're a little bit naive. Because I think that it is so important nowadays that we have an expectation of privacy in our technology. It is paramount, in my opinion. That simple example that I just shared with you of you getting in your car and you leaving to go home at the end of your workday, and your phone already knows where you're going. You know, the data and information that is collected on each and every one of us every single day is in my opinion, scary. I participated in the, when I was Chief Assistant Prosecutor, I participated in a Prosecuting Attorneys Association conference back in 2014. That conference had advised us, and if you guys remember at the time, in 2014, there was this incident going on in the St. Louis, Missouri area, much like there is today, about the killing of a black man that was involved in a criminal investigation, and that led to riots in the St. Louis area. So the Missouri State Police at that time had suggested, because this internet group called Anonymous had hacked several individuals in the Missouri State Police's personal profiles online. So the state of Missouri had decided that it was a good idea then to have all of their state police and everybody that was in the state enroll in the online identity theft forum. The name escapes me at the moment, but this identity theft forum had ensured that you were guaranteed up to $1 million in damages. So what had happened is the state of Missouri had enrolled all of the Missouri State Police in this program. The members of Anonymous, this hacker group, had changed all of their passwords, so now they couldn't even, the individuals that were sought to be protected couldn't even access their own information. The dangers of technology are greater than ever nowadays. The Fourth Amendment is paramount. We have a reasonable expectation of privacy in the things that we consider to be private. And I consider that to be your cell phones, your emails, things in within your home, and without the necessity of a warrant for government to intrude upon those things, in my opinion, is offensive to the Constitution. That's our constitutional right to have privacy in those areas. And there has to be probable cause demonstrated in order to invade those places. It's very simple in my opinion.
Thank you, sir. All right, I'm going to come down to the next candidate. Proposal discusser? I think I like this one. Yeah.
Blue button, there we go. Listen, the Constitution has a series of amendments. There are 30-some amendments. The first 10 are the Bill of Rights. And the Bill of Rights are about the individual protections guaranteed to you as an individual from governmental intrusion. Governmental intrusion most likely is something that it's from the law enforcement side. It's police agencies, police officers, invading your privacy.
Could also be regulatory agencies.
It could. The proposal, though, does not have to deal with the government. We already have the constitutional amendment that protects us from individual searches and seizures of our private areas. The proposal here is to make other entities have the same requirement as a constitutional amendment. That's pretty significant request for a proposal on the ballot. So I'm not sure where that's going to go, but these are the highest values, as we all know, as it relates to the protections afforded to us as individuals and guaranteed by the Constitution. But we have all sorts of doors open when you start talking about regulatory agencies, individuals who have invaded your privacies. Now, that's not the government acting, and there's no Bill of Right protection for that. So what's the remedy, or what's the protection for the individual, since it isn't the government that's acting? So the answer is there are civil claims of redress, and that would likely be something along the lines of invasion of privacy or things of that nature. But that's an interesting proposal, and I'm sure the sheriff is more up on it than I am.
Well, I think it deals with intellectual property rights, computer access, electronic devices, digital equipment that they're addressing.
It's any electronic device.
Yeah.
Here's why I love Lapeer County. So proposal 2, normally, to be honest with you, I'd sit up here and have no idea really what you were talking about as we're getting through that part of it. But Lapeer County exploded on this one. And why I love Lapeer County is because they came to our defense, to law enforcement's defense, truthfully. They said, because we're putting more limitations on law enforcement. It was right, it's in the middle of defund the police, that this was a shot against us, that we were trying to, that they were working against us being able to do our job. This, to go on the ballot, passed the House and the Senate unanimously. Right. This changes our job zero. In Lapeer County, we have been doing, what they did is basically they're adding, because of the times and catching up, they're adding electronic device and communications, blah, blah, blah. That's my all they're doing is adding that in there to catch up with the times that we're on. Right. We have been doing, even going back to my days in Genesee County, we've been doing this of a CYA, to be honest with you, search warrants on electronic devices, communications, cell phones, all the other things. We've been doing search warrants on those prior to going through them for many years. For our daily operation, and I can say for Lapeer County, I can't say for some of the other counties on how they do it, this doesn't change our day-to-day whatsoever.
Okay. Judge?
I think that pretty much covers it. It's the expectation of privacy, and anyone under a certain age treats their cell phone as an appendage. It's just something they've grown up with, and you use it for every possible imaginable purpose, and you would consider that a lot of those purposes are private. So I don't have any argument with what the sheriff's indicated.
I had this discussion with Chief Broussard in Oakland Circuit Court almost 30 years ago. He said this was going to be one of the issues, and it has to do with the children abuse and so forth, digital pornography and the devices. So you have to have probable cause to believe and get a warrant to do that. Judge Warren, do you have any comment on that proposal?
Sure. There was a United States Supreme Court case back in 2018. It feels like years ago, called Carpenter versus United States, and it basically held that if you want to look at somebody's locked cell phone, you've got to get a warrant. So, I don't think I agree with the sheriff from what I know of the proposal, what I know of current jurisprudence. He may have been CYA-ing for a long time, but he was right to do it because this decision did come down and kind of dispel those gray areas, so to speak. Just a general comment. The Fourth Amendment is an incredibly important protection for our freedoms and liberties. It was fought for in the United States before it was the United States in America, starting in 1761 with James Otis. developed eventually into the jurisprudence of the Fourth Amendment. And there has been a hollowing out of that protection over the course of generations. It's making a bit of a comeback, and I think that for those people that love liberty and freedom, this kind of initiative is a good one, and I think it makes smart law enforcement because you don't want to have people. The more you can put out there is that smart sheriffs will, and other law enforcement will say, yes, let's go do this before we violate someone's constitutional rights. I just think it's an unassailable direction. I don't want to put too fine a line on it because the language may have some unintended consequences and it might show up before me or the other judge. And who knows how a particular case would flush out, but I think certainly this idea of expanding our rights in connection with that device, which is so important to a huge amount of our population, makes sense.
Judge Warren, you didn't run your marathon with that device on you, did you?
I did, actually.
You did. Say, no, I'll talk to you about that later.
It was in a belt. So.
All right. I want to sort of combine the discussion a little bit now. I want to go back to the First Amendment, and I want to talk about the right to assemble and peacefully protest. Then I want to talk about the groups that are organized and it's been in the press, the Antifa groups, the Black Lives Matter groups, and crimes that are committed during the peaceful protests, crimes that are observed in your presence. Hopefully we don't see anything like that in Lapeer, but if we did, I'm curious as to what's the situation and impression. So I'm going to give this to the sheriff to discuss first, and then we're going to pass it through the legal geniuses, as they say.
I'm not sure exactly what you're asking, but as for, we have obviously the two protests that we dealt with within the county. I know there were some smaller ones in Emily City and stuff too, but we haven't had that issue. And Black Lives Matter was one of the ones that put the one downtown Lapeer. We haven't had that. We're blessed because of where we live, again. I think the other part is the groups that came to us, myself, in these cases, myself and Chief Frisch, both met with these people. Prior to set up the parameters of it, we had people there. Chief Frisch and I were there with them. We went up to make sure that it's not, because if it's obviously with our amendment right, they have that right. And as long as they do that peacefully, I support 100%. Now the part of, and you brought up someone earlier with Chief Craig, I align with him and how we feel about that. Peaceful protest, and obviously you have that right, and we're going to protect that right as long as we can be, just like every other amendment that we have on here. But on the same side of it is, if you're going to come in here and you're going to destroy or you're going to loot or whatever it is, we are going to hammer you. It is not under the law. There's no place for that in Lapeer. And I think because of the way that we set up and the things that we do, we make that very clear from the beginning. When we sat down with them, we said, here is the things that you are there. We are there to support you in your message, depending on what it is, and show that law enforcement, because what I really liked about the protests we were involved with, it really wasn't, especially because that was right in the middle of the Minneapolis stuff, that's not the way other protests were going. They truly were not anti-police. They were anti-brutality and some of the things that happened with it. And so they handled it very well, knock on wood, and we're blessed that we haven't had those issues. But I think when you're seeing Portland and you're seeing some of the other ones there, they allowed them to take control.
Right.
And that won't happen here.
What I want to address is the process. If I come to you, if I want to protest, or I want to gather an assembly, and I want to address a political thing, do they come to the police department for a permit?
So it depends on the jurisdiction you're in. And like, for example, the city of Lapeer. And Chief Frisch, I commend him on this, is that one was basically, those were young people that did our two protests that started, as we've talked about a million times tonight, through social media, is how everybody got wind of it. And then we started calling. Instead of calling, and Chief Frisch, very simply, because you have a process in the city of Lapeer to get a permit to do that, especially at a park or at the library, is where the other one was. Chief Frisch came to him and said, listen, I'm not going to, he could have shut that whole thing down because they did not follow the process. They were younger kids. Okay. He said, we understood, or we both met with them, both talked to them, and said, here's the things, you should have went this process, but we're not here to fight you and your rights. Here's what we do next time, if there is a next time. And then we worked through them, and it was fine. Ultimately, by us, and that's where I commend Chief Frisch and how he handled it was, because it's his city, is he truly could have stopped that, shut that down, and not allowed that to happen. What would we have done at that point? We would have just created more pushback. So then for us to go, why not do that so that we don't have the behavior that we're seeing across the country?
Can you elaborate for, if anybody watches our TV broadcast and they want to get a permit in a certain jurisdiction, how would you direct it? Go to your township official, go to your municipality official, and ask for instructions on how to...
They just have to know where they're having it at, obviously, and to talk to the township and then the local law enforcement. Obviously, we have different, it was mentioned earlier about the different agencies. We handle a lot of the townships, like the Sheriff's Department does, and a lot of those will fall back on the township themselves. But start with the municipality and the location that they have and check with that local law enforcement.
Byron, who is in the audience, did we turn this on? I don't remember asking that question, but it certainly wasn't an inquiry. But I've put on probably 300 athletic events in my time throughout various jurisdictions, and I always get a permit. So I just, just a general frame of reference. Anyways, so that's the Fourth Amendment issue. Does anybody else want to comment further on that issue? Judge Konschuh, anything? All right. Then we get the 14th Amendment. No. Cruel and unusual punishment inflicted nor excessive fines imposed or bail required. We've seen, this is a general question dealing with, again, Lapeer is a little different than places like New York that has imposed these new statutes regarding capture and release almost. You arrest somebody and you give them free access to bail and release them on the street. New York was having a terrible increase in crime and so forth. Can you address, and again, I guess it's Scott, you might want to address your thought observing what has transpired throughout the country, including places like New York, places like Seattle, Portland, and so forth.
I can. It's probably better that the prosecutors do it.
Okay.
And the only reason I say that is, obviously, we see it. We're blessed not to have that issue here. I think it's a huge problem seeing we just saw the Houston police officer that was killed from somebody that had just been put out, an illegal immigrant. This happens a lot, and unfortunately, our job is to protect the public, second to none. So by putting that part out there, I think that's a larger, that could be this one could be a whole topic of conversation alone, but I think it's probably better on the bail or bonds and stuff like that to be.
I'm not sure what the question is. There is a process, and the Constitution protects a criminal defendant's right to a bond to be released. That's a balancing test that a court will have to review, and issues related to the severity of the crime are first and foremost the history of the criminal history of the person before the court, and the likelihood that the prosecutor's case will result in a conviction, and the threat that the release of this person poses to the community, and lastly is the likelihood of flight. So these are issues, and we debate these issues each and every day in the court.
Well, I guess the question is, in certain jurisdictions other than Lapeer, we have a legislative action or a municipal action dealing with modifying any bail requirements whatsoever. And it could be a very severe crime. Burglary, robbery, could be some kind of violence, assault. how would you feel as a prosecutor with your law enforcement agent, your sheriff, when you effectuate an arrest and go before Judge Konschuh, and there's some law says that he absolutely has no authority other than to follow the statute and says release the person without any bond whatsoever?
Well, there's a couple issues mixed into that question, and if there was such a law in the state of Michigan, we're sworn and take an oath to enforce the law. That would likely be challenged by prosecutors, and it would be likely challenged by the Attorney General, and the Prosecuting Attorneys Association would likely have a say-so in that in the legal briefing process, assuming our legislature passed such a law. As a prosecutor, the objective and goal and the number one priority of the prosecutor is to protect this community. And protecting this community is something that requires a bond, I think, in some situations. Not every. We are pretty trusting, is probably the word, in the local criminal justice system here, and many people are released on personal bond. But there is some sort of balance test or relative guess that we all try to make with confidence that we're making the right decision on the release of an individual, and whether they'll return or whether they will reoffend or commit another offense.
Okay, I have a follow-up. If you're acting as a prosecutor, do you ever confer with defense counsel that's representing or the indigent defendant and determine whether or not you can work out bail requirements before you go before the judge and ask for a certain bail or bond?
We don't with individual defendants. I can't say we've ever done that. As to defense counsel, yeah, that's discussed, debated, and sometimes agreed.
Okay. Let me move to Maurice. We have another. Yes, Ian. Before I get to
certainly. Oh, I didn't mean to interrupt you, John. I do have a question, and my question is that what has the pandemic and going through the pandemic, what revelations or what changes or what policies have been changed in regards to both law enforcement, prosecutors, and the judicial, the judges, and how has that affected all of that, and how is that going to affect it moving forward? Because I want to bring it back to Lapeer County, quite frankly.
I think I got the mic on here. So I'll answer the part of the discussion that we were having, and then I'll answer Commissioner Kemp's question as to how the whole judicial system relates to the coronavirus issues that we're dealing with. First and foremost, my position as prosecuting attorney for this county, if there is things going on here like there is in Oregon or some other place, I have no tolerance for that. I have no tolerance for lawlessness when it comes to destruction of businesses, declaration of autonomous zones. I will be at the courthouse all night long waiting for law enforcement to bring me the warrants to authorize on these individuals, personally, because I think it's unacceptable that government stands by and lets business owners, property owners, suffer these losses at the hands of people that are out to protest. Now, at the same time, I'm all for people's right to speak and people's right to protest, but do it peacefully. Someone's right to protest doesn't come at the expense of some other person's assets or loss or detriment. That's the cornerstone of our democracy. There is a peaceful right to protest. However, when that crosses into lawlessness, and that crosses into destruction of property, and the breaking of laws, That's my job as prosecuting attorney to step in and stop that immediately, and with a harsh hand if I have to. So given that circumstance, should God forbid that event should happen in Lapeer County, I will be there ready and have law enforcement's back in enforcing the laws of our state and make sure that no one else has the opportunity to protest at the expense and loss of someone else, because that is what our democracy is all about. So hopefully I've addressed that question. To go on with Commissioner Kemp's question regarding how the pandemic that we're experiencing here has impacted our judicial system, it has. We have not had jury trials since March of last year, or March of this year rather, March of 2020. We're slated to commence jury trials in February or March of 2021. There have been other counties that have commenced jury trials, and I'm not sure really that government is really prepared to respond in an efficient manner to this pandemic. I don't really think we are. I don't think, because I'm hearing that other judges in other jurisdictions are saying, well, we're going to have jury trials, but we're going to have all the jurors appear, and there's going to be, you know, these plexiglass partitions between every single juror, and then attorneys are saying, hey, we can't make argument with masks over our face, and I agree with that wholeheartedly. So there's some practical applications that we have to overcome in dealing with that, and it is set the whole judicial system behind. So when I take office in January, there's going to be a situation where I have to look back and try to catch up on jury trials that have not been conducted since roughly March of 2020. And then we have, everyone has a constitutional right to have a timely trial by a jury of their peers. We have to keep that in mind going forward and try to accelerate forward in giving people justice in the time that they deserve it in, right? So it's a double-edged sword at this point in time. But I do think there's, and this is my own little personal soapbox I'm going to stand on for a minute, I do think there is a intellectual gap between the science and medicine of what's going on with this pandemic we're dealing with and the practical applications of everyday life. I think there is a disconnect there. I think there's a huge opportunity for government to lead this conversation with a science-based discussion saying, hey, you know, we recognize that all you folks have a right to go out and do what you want to do every single day of your lives, right? I mean, you all probably have friends that smoke, and you probably still hang out with those friends that smoke, even though on that package of cigarettes it says, if you use this product, you're going to die. But that's our choice as Americans, right? We choose to interact in that or not. And I think you have to extrapolate that mindset to a certain degree into what we're dealing with today, because we could all quarantine at home. We could all sit at home and say, hey, we're not going to participate, we're not going to go here, we're not going to go there. That's all our right to do. But I think there has to be more science. There has to be a more science-based conversation in how government applies some of the precautions that are probably appropriate under this pandemic, and to caution people to say, hey, this virus is something that's real, and it's something that you can catch. And if your health is compromised in some way, this could be fatal to you. I think that people have to understand that going forward, but government has to lead that conversation and inform people of that before they go out and make their own choices. But I don't think it's government's place to tell people you can or can't do this, or you can or can't do that, especially when it comes from one branch of government. I truly and wholeheartedly believe that it has to come from a law passed by the legislature and signed into effect by the governor. I mean, that is the foundation of our government, our governance, and that is what the laws that we live by are established. That's how they work. So in answer to your question, Commissioner Kemp, in a roundabout way, yes, it is an issue that we all have to deal with. I think there's more information that has to come forward. I think there's more interaction and leadership in that message that has to come from government other than just telling us what we can't do all the time. I think there needs to be more precaution and advisement as to how we proceed in life every day, because we eventually have to get back to that.
I'd like to have Judge Warren address this, because he's a different jurisdiction, and then we can come back to Lapeer County. Obviously, Oakland Circuit, we're still in the same, we were in the same regimented district that was under the scrutiny and the quarantine and the lockdown. But what's happening in the Oakland Circuit Court in the Oakland County area that maybe you could inform us that might be a little different than what's happening in Lapeer?
Well, I will make this short. It's very similar to what has already been discussed, with the exception that we have been Zooming. So I'm Zooming now, right? So I'm in my study. I usually don't have the flag behind me. I've got kind of a virtual courtroom behind me, and we've been doing almost everything virtually since March. It kicked in the day after our Patrick Henry dinner for the Patriot Week Foundation, so we were like the last event in the state. We were very pleased at Patriot Week that we could have that event. We tried to have a jury trial this Monday. We have retrofitted our courtrooms. We've have all the protocols in effect. We've got all these stickers around that show the social distancing and all that kind of stuff. But our case numbers, which were going down, went up. And so they pulled back on having the jury trial. So it is a week by week kind of determination about when we're going to go back. We have to have the approval of our health department and the Supreme Court Administrator's Office before we're allowed to move forward. So like was stated earlier, we haven't had a jury trial in our county since March. Almost everything else we've been able to do. I've had violation of probation hearings, evidentiary hearings. I've taken pleas. I've done sentences. It's slower. It's terrible. It's awkward. But we meet all the constitutional requirements, and so we are getting through a fair amount of our caseload. But the big thing is the jury trials. We're going to be stuck at least for a few more weeks before we can do that. I heard that Macomb County or Wayne County had a jury trial, but it's interesting. I heard that was going to happen, but I haven't heard anything since. I'm not really sure if that actually flushed out or if it was like here in Oakland where we had to cancel just this week.
All right, let me ask Judge. Let me ask Mike his.
Maurice.
Yes.
I guess if I could, my question was a little bit more about lessons learned moving forward. I mean, I think we all understand what we've done. Lessons learned moving forward. What does this esteemed panel foresee?
Blue button. I like the question, and it's a learning process, and what we have learned is that we get smarter and smarter the more we have the issue before us. Take Zoom. The judge just mentioned it. He's here. We are using the technology for the roadblocks as an administrator in a bureaucracy seem to have been somewhat lessened, and the use of technology has improved the way our office operates in a time that we've been pushing for changes a long time ago. For example, remote access to computers. Lawyers, I can speak to, have to deal with cases, the evaluation, the authorization of warrants, and they can do that remotely. That technology was not there. That technology's been there, but the use of it hasn't been there. But this all seemed to move at a fast pace, and we have made lots and lots of technological improvements because of that. The speedy trial constitutional protection, and that's the right to a speedy trial, that applies to those who are in custody. That's the key component to the triggering of that event. And the sheriff, I'll let him speak to that, but we have a 120-bed facility, and we have about 40 people in the jail now. And I think it has also forced us to truly examine other alternatives, for example, for those who are awaiting trial. The issue of bond was a question before. Now we have, with the efforts principally by Dave Stevens, our Community Corrections Director, has implemented the use of tethers. So this type of technology has changed things, and it's changed things, I think, even from a fiscally more responsible way of dealing with the criminal justice system. Because what we do each and every day and each and every week and month and year, we process large volumes of cases, and most cases don't go to trial. Most cases, it's 90-some% of the cases are resolved. So I think we keep getting smarter. The use of technology has been a big improvement, and I think it's made our criminal justice system actually better, in sort of a twisted way of looking at things.
Sheriff McKenna? Sure.
So about the end of March, we actually called I called a staff meeting with all of our command. And what I asked them to do from that point on was to keep notes, keep track through this on the positive, basically to be able to have a debriefing at the end of this, whenever that actually is going to be. But I wanted to see the negatives, the positives, the things that we could do better in that. So we've been keeping track of that, and it's an interesting, and I love the question because I think that's how we improve with it. We, like everybody else, drastically had to change, and the jail being the huge element with it. I think one of the things that got forced of where did we really struggle, and I think this county knows that, is technology-wise. We found that we were behind in a lot of areas in technology. Now, and I think this is in all spectrums of society, we've got pretty good through it. I think we found a lot of ways that, I'll be honest with you, me personally, I'm not a tech guy. So when there's a lot of things that I normally would be intimidated by, I was forced to use those and now realize how easy it is. So even from, like on the positive stuff of, obviously we know the logistics, or Commissioner Kemp would, we're transporting prisoners back and forth to the jail or to the courthouse all the time. And it's very hard because we only have 2 deputies down there. It's forced us to be able to do arraignments online through the office to where we're not putting that. Because that's every time you jump in there and every time you're transporting somebody as a security measure. I think with some of the upgrades and things that we've done, I think that'll stay. I think that'll be something long-term that is better for everybody, not only for safety purposes, but for people's day-to-day. We changed a lot of where I think a lot of the people did. We have our jail, and the prosecutor's right, we're a 123-bed jail. I think currently today it's right at 40 is where we're at. We've been at that. Obviously there was a large push through the executive orders to get rid of a lot of them, or as many as we could. I stayed on the side of, there were a lot that I wasn't comfortable with, so we didn't. We followed, obviously, our gut with what we felt was best for Lapeer County. But we have a 3-pod, our jail is set up where we have 3 pods that those 123 people have beds in. We were able to adapt, because that was one of the biggest parts, is how do we do this? So it basically was a system of check-in, quarantine from the beginning. So learning from there, at first when we went, holy cow, how are we going to pull this off? I think it made us more efficient, truthfully, in how we do things. Now, granted, our numbers are down, so that's easier. But I think when we get up to a higher number, I think we have a better process and a better day-to-day in there now because of the new parts that we have. From the road stuff, we're going away from the times of, obviously the COVID part of it is, but we found the same thing also of, we're not able to shut down. Obviously we worked through the entire part of it. But remotely, for our detectives, for our MEIs, for our accident reconstruction, technology-wise, we've set it up to where they have their home screen for their computers. I know everybody does this, but that we can do that now to where if we shut down tomorrow or something that happened with it. I think even part of our day-to-day operations for the road, it's very common in a roll call. You might have 10, between contract deputies and general cars, you might have 10 working at a time. We were able to kind of spread our shifts and make them into platoons, which even at times in coverage might be something that we look at after the pandemic, because it worked in different areas. Not only did part of the COVID and not having to, if we did have somebody that tested positive, we have to quarantine a large number of shifts, but there were a lot of positives that came out of that. I think the negative stuff is, the negative things, I'll have a better answer once we do this, because I do look forward to the debriefing side of it, and there's every day something's coming up with it. But the end result of it from the learning part is, I mean, if with our numbers down at 40, that's a domino effect, not only with our programming in the jail, monetarily what we get, community corrections. When that goes to that hits every part of that. So I really do believe in the long run we'll become more efficient, and we have become more efficient. Things that I think we'll look at hopefully post-pandemic. And then once we do, and my plan is once we did get to that hopefully end game, is to meet, put all these things together, and do a complete debrief for the county on things that we did very well and things that we did poorly that we need to improve on.
I got a follow-up, just very simple question. Is crime up or down during the pandemic?
So during the actual pandemic, we were in a range anywhere from April to April is when we really started tracking at the beginning of April because of the real shutdown in March. We averaged, on average, was about 24%, but between 22 and 26%, we were down call volume during this entire time. We are back to normal now.
Meaning up?
Yeah. Well, I'd say on average. I wouldn't say up. You're going to see trends in it. You know, that changed everything. And people say, well, why wouldn't you're always going to have violent crimes or B&Es? Well, people are home. You're not going to have that much. Where we really saw skyrocket, especially the last 3 months, was mental health, domestics, and a lot of drinking and driving. But overall, I think we're caught up to where we were. Matching-wise, call volume for last month was within a couple hundred of 2019 numbers.
Okay, now I think we're going to conclude with just a summary of what's happening in the Lapeer Circuit Court, and we've gone beyond our time period, but it's been a very, I think, worthwhile time. But Judge Konschuh, what's happening with the court?
Well, as a circuit judge primarily assigned to the family court, there are only a couple categories of cases that I handle that would have the ability to demand a jury trial, and that's juvenile cases and abuse and neglect cases. And so far, through the past several months of the pandemic, almost all of those cases have entered pleas, so I haven't had the problem of falling behind in my docket. I think I'm pretty much up to date. What we've done in the past is to do the Zoom hearings. I can't do a cattle call for the docket anymore and have a bunch of people in the hallway in the courtroom, so we're scheduling motion hearings every 15 minutes, starting at 8:30, 8:45, 9 o'clock all morning. And if I find that a case needs a little more attention, I'll set it over for an evidentiary hearing. And that cuts down, when you have those scheduled Zoom hearings and attorneys show up, they don't have the excuse of traffic or anything like that, so it's become pretty efficient. And I think moving forward, we're going to be, I think, taking full use of Zoom and offering it as an option. Right now, I've got cases where I've heard all the participants by Zoom. Part of the participants are in the courtroom, and some are on Zoom, as long as we're following all the protocols and cleaning up everything between hearings and keeping the limited number of people in the courtroom. It's been very efficient, and things are going very well. And I think the Zoom technology, especially now that we know it works, everybody's used to it. It's compatible. If you have like a prosecutor may have a witness from out of town who only needs to testify for half an hour, they can Zoom in, testify on Zoom rather than having to have the government pay for a witness to come a long distance, potentially put them up overnight, or have an expert witness come in from a long distance where you can just have them Zoom in, and it's going to cut costs quite dramatically in some of those types of cases. So we found that the learning curve was a little steep at the beginning, but when you catch up to technology, and it's pretty user-friendly, and the biggest thing is to get people to unmute themselves. Other than that, things are fine.
I have a follow-up. The Zoom, let's just get the scenario where you have an expert witness, let's say it's a physician, who always has problems doing depositions for your medical cases, for injury and so forth. How do you, if you use Zoom, how do you swear that person in? Does the Zoom, just out of curiosity, do you do the Zoom, did you do an oath by Zoom? Or
Yeah, I just ask, like Judge Warren, to raise his right hand, swear him in.
is that's pretty much, that's permitted?
As simple as that would
That's
be.
the acceptable procedure now?
Absolutely.
Okay, that's what I wanted to know.
Yeah. One more question if I could. My question is very simple.
Just thumbs up, thumbs down. Through the pandemic, you gentlemen have all been very flexible, and we appreciate that very much when it comes to alternative sentencing. So, in the long term, in your long-term projection, in your best crystal ball, alternative sentencing, a positive thing or a negative thing?
Thumbs up or
Alternative sentencing meaning all of the electronic, surveillance or electronic, what do you call it? The ankle band and all the things that we've done to keep the inmates down, the cost down, and face-to-face down. So just curious.
The answer to that question is crystal ball.
I'm asking you for your crystal ball.
John's got a crystal.
You're asking for a very generalized answer to a more complicated question. So you have to take into consideration what the offense was that this person is being imposed sentence on. And then whether or not some kind of electronic tether or monitoring, or what type of monitoring is appropriate for that individual under the terms of probation. So obviously someone that's has a drug-related offense conviction, you would ordinarily expect some term of incarceration probably. Under a traditional sentence, you would also expect some type of alcohol or substance abuse monitoring or testing as a condition of that sentence as well. Obviously, if they're in incarceration, there's no need for monitoring, right? Because they're in the jail or they're in the prison, we know what they're doing. But if after that time has been served, the time of incarceration, and then they get out to a condition of probation or parole where they're out in the public, it can be very useful, right? So if there is a substance abuse offender that we're trying to monitor, that there is a tether device or some other device that can decrease the overall cost of incarceration and impose the cost of monitoring on that individual, which those sentences usually carry that. If there's an electronic monitoring device that's ordered as a part of sentence, that individual bears the expense of that rather than the public. So those types of situations are appropriate for that. However, take into consideration someone that's been sentenced on a crime of embezzlement, for example. How do you monitor that electronically? You really can't. So then you're in a more traditional phase of this individual is either incarcerated or they report to their probation or parole officer periodically. So there are circumstances where monitoring and technology can facilitate lessening the cost to society, but there are other situations where it can't. There are situations where more traditional means can only apply, I think, and there's a lot of both. So that's the judge's job when that individual is being sentenced to decide what sentence is appropriate for the crime committed.
Yeah, I was going to probably get past that microphone right on over here to the two on the end, and then we'll end the...
Well, I guess if the question is alternative sentencing in general, having those tools in your toolkit as a judge, thumbs up, yes. Any kind of alternative you can do to straight up incarceration that you have in your arsenal is a good thing. So there, as John mentioned, there's electronic monitors, alcohol monitoring, all kinds of services and treatment that you can offer. And if those are appropriate, that's good to have them available.
I would agree. I think the only part that I do say that we need to look at, and it comes to, it's a case by case. If somebody's it's a property crime or something smaller, they got a family to care for, or they have a job that they're going to lose, whatever it is, we have to look at that. Now, are we talking second, third, fourth, fifth time? But I do want to point out that tether seems to be, I look at it as a pacifier for a lot of people of, oh, it's fine, he or she is on tether. They're going to have consequences for what they do, but we still have no control over what they do. They can leave that premise or wherever they're at, and it's going to go off, and we're going to be aware of it. Then now we're looking for them. Or so it's one of the parts where a lot of time I hear that all the time. No, it's good, especially defense attorneys will say he's doing this, and we're going to be able to keep an eye on him. Well, you are until he leaves that location, and then we're chasing him or her around also. So I do also give it a thumbs up, but the public does have to be clear that we really maintain no control over that person if they are going to go and do something horrible.
Let me get Judge Warren's last comment on that. Your thoughts on that question?
Before I do that, I never got to do my commercial, so just very quickly, if you love America and you're interested in our history and our founding first principles, we have Patriot Week, which was co-founded by my daughter and me about over 10 years ago. Go to patriotweek.org. I've also written a book, America's Survival Guide, How to Stop America's Impending Suicide by Reclaiming Our Founding First Principles in History. You can find it on Amazon or americasurvivalguide.com. And we got a great podcast called Patriot Lessons, American History and Civics. Alternative sentencing has a lot of merit if it's done by the judge thoughtfully and it takes into consideration the specific individual circumstances of the defendant. If it's just an easy way to clear out the jail, to stop jail overcrowding, or to get an easy plea because you're agreeing to alternative sentencing, I think it can be a terrible idea. It's very much like the bail issue that was talked about earlier. If it's done well and considered, I think it have great advantages. And I'm known as a very tough sentencer, I think, in my county. Probably the toughest or tied for the toughest that there is. So I take sentencing very seriously. I think punishment has its role, but I also believe in rehabilitation and having people redeem themselves by taking responsibility and accountability for their lives and being contributing members to society. So I think it's a delicate balance, and so the question is, or the answer is sometimes.
Judge, just to follow up, the Oakland County Jail is overcrowded, is it not?
The Oakland County Jail has had chronic overcrowding throughout the years. Not at this time. Right now, I think it was alluded to earlier, we have cleared out a lot. We got a lot of empty space in our facility at this point. But it's normally, under normal circumstances, has been kind of on the cusp of overcrowding, and sometimes has been overcrowded. We've had to release people.
Okay. All right. I think we have exhausted. Oh, we had one question. One question.
Yeah, it's a right to privacy, and I can't remember names, so I want the guy on the screen to answer the question.
Okay, the guy on the screen, Judge Warren, you're going to be zoomed in.
What it is, I hired a girl, and I knew her background. She was a drug addict when she was 14, 15, and up to 17. And then I turned around, and then she quit. She went to school, and then she come to work for us. And I've had her for 4 years now. She's perfect. She works her hinder off. Her dad don't know how I ever got her to go to work. She handles 30-pound units. She's a wonderful girl. But on right to privacy and Google, and they all do it, you can go in, and no matter what you do, it's in the cloud for life. And all I have to do is pay in a program, and I can have all your records, and I can see everything you did, no matter what position you're in there. Now, how do they get by with that? I know they have contracts when you sign for Google, Facebook and stuff, but that goes on all the time. And you can find out anybody that you hire, you can go and get their records. And to me, that's a violation of rights to privacy. Okay? Thank you.
I guess the question is, how does Google get access to this information? I don't know. Judge Warren, you do that, or Scott?
Are you talking about arrest records and stuff, sir?
Yeah, no, they take your whole life. If you go to a party and you video it, it's in the cloud, and we can find out everything you do off your deal, even though you delete it. Now, if that ain't a violation of the rights to privacy, I don't know what it is. I don't do it.
Well,
And it's in the cloud, and they have the records for access. That's why I think that they should not be able to keep any of your records at all, like for a month or 2 months, and they have to be disbanded out of the machines.
Well, I think it's an access to the contract issue.
So, if you're, a lot of the pictures, and I talk at the schools about this stuff all the time, with social media, and I talk to all 5 school districts, 5th through 12th, about exactly part. Because a lot of these kids are doing things in high school that are going to haunt them for the rest of their lives. The problem is a lot of these things that they have are on platforms called Snapchat, Instagram, Facebook, whatever it is. Ultimately, kind of like what a lot of people do is when they sign up for these, they're zipping through. They're choosing to have that in their platform and are signing and pushing okay that they accept or agree to a lot of these things. Now, that was my message to the kids, is it does never go away. And we, obviously, as law enforcement, you can have, to get a search warrant on a phone or whatever it is, we'll get the very first text or picture that was ever sent on that phone. I can't really say because ultimately, these are things that people, a lot of the platforms, the social media platforms, these are things that those people are putting out into a public site that's ultimately taking away a lot of their privacy issues. So I agree it's a huge problem. I agree, I don't know lawful-wise on how that is, because they're agreeing to put that stuff on there, the person themselves, and then obviously it's going to haunt them later. But it is a tough part, and that's why we preach nonstop, and that's why I go to the schools for people to realize 80% of our background for law enforcement right now is your social media platforms, is we go through all of your stuff to see what you have.
They can go to a party, get drunk, and do all this stuff. It goes on social media. Then when a manufacturer goes look for him, oh, here's this person drunk, looks really good. Oh, you got this picture that they sent to their boyfriend on there. They got everything on it. All their records are in that cloud.
No, it is, but
And you can't get them on it.
but from the lawful side that's a public site that they chose to put that information on there. So it takes the law side of it out of there because it was their choice. I guess the moral of the story is, for me, I can say is, I'm really glad I'm not a kid in this day and age.
Well, to me, they should take it and they should have a limitation of how long they can hold your records in that cloud.
Well,
4 years or 5 years, they got double.
Judge Warren, do you have? Pardon?
Try to respond briefly.
Yeah. Okay. I was going to have you corrected it.
Just real short, because if you look at the laws of the European Union, the electronic data and information that is shared in a community like your email or your social media, the laws in Europe dictate and regulate that far more harshly than the laws of the United States do. Basically, the laws of the United States say, hey, if you want to be a user on our site, you have to agree to let us keep track of everything you do here. And you know, how many times when you get a new cell phone do you read the entire contract and agree to, you know, the 14 pages of, you know, number 8 font print that spells out all of the terms and conditions of using that product or using that platform. So I think that's a much larger discussion that needs to happen at the federal level in our country, because I do believe it is an issue just like you do. I do believe that it's something that's unfair, that corporations have an unfair advantage, that Google has an unfair advantage over every person in this room as to how they use their media, as to things that they should enjoy a right to privacy to. So, you know, I just wanted to comment that there are countries that recognize the situation. Our country is not quite there yet.
Just as a follow-up, the curiosity is, he's talking about, it could be a minor. Sure. What happens if you have a minor who's got the cell phone, and usually the minor has the right to disavow the contract, so he should also be able to have the right to exclude or expunge all records taken from a minor under that contract provision. That's just a thought. I just raised that. And this young lady has a question.
I don't have a question. I wanted to address you specifically. I am a member of the Parent Coalition for Student Data Privacy. I think I'm the only member in Michigan, to be honest with you. And There's COPA, which is the Children's Online Privacy Protection Act, which protects children 13 and under from corporations and entities from collecting personal private data from any child under the age of 13. After that, it's a user end agreement that if you're using your cell phone, when you purchased it, you're using your cell phone, you automatically, just from the purchase and using it, you agreed to their agreement, their privacy agreement. So there's really nothing, the only way to get out of it is don't use the platforms. That's pretty much the only way to get out of it right now. There is one state, when it comes to student data privacy, there's only one state that has very stringent standards, and that is, or stringent laws, and that's in Colorado. I'll be honest with you, I don't believe we have any legislatures with the backbone to be able to pass anything here in Michigan, because Google, Apple, all the big tech, Microsoft came in when they were discussing that legislation before the governor signed it in Colorado. They came in droves and tried to intimidate the legislatures to withdraw their support. And yeah, I don't think we have legislators with that backbone here to pass that type of legislation. So.
Thank you very much.
This girl was 15, 16, 17. She was incarcerated. She had all kinds of problems. That's all on her record.
All right. With that said, Judge Warren, he directed that question initially at you. Is there anything you want to add to that?
Well, the only thing I'm not on mute, am I? Okay. The only thing I would say, I guess this kind of goes back to the comment made by Judge Swartzle in connection with the social media realm in general, is be careful what you're using. I agree with all the comments about people signing away their rights without paying attention, the need for more understanding and attention to those things by the users. This is similar but a little different, but it relates to what we talked about earlier at the beginning, is that really, if you don't like the media, the social media that you're using, this is the problem. People have this expectation that they're going to be treated fairly on certain social media platforms. It's obviously not true. I mean, I think it's obvious that Facebook and Twitter are taking political positions, are suppressing certain information. So the way to deal with that in the marketplace is not to regulate them, because the power to do good is the power to do evil, but to create alternative platforms. And there are these other social media platforms that are out there that provide better privacy and that are unmediated in the way that we're concerned about. One is called ThinkSpot, which is coming up. I don't know if anybody knows who Jordan Peterson is, but he's very much supportive of that and working through that. And there's going to be others. So the way to move this is to join other organizations to effectuate change.
Thank you very much. And to my panel members, all of you, and the people in the audience, I appreciate your attendance to this meeting. I hope that it's a very difficult time in our history. You know, from the time we summarized from all the events that transpired in this year, like it was pointed out by Judge Swartzle, that would be a decade or more. Here we condensed all these activities that we are involved in less than 7 months. Here we are, we're approaching the presidential election November 3rd. We have crucial decisions to make and issues, and we're fighting through a pandemic. We're fighting through constitutional issues as we talk. Delegation of authority from the executive branch, the legislative interaction, inability to get legislation passed because we didn't have cooperation. But we still are under a sort of an edict in an emergency situation. I trust and hope that this informational and educational forum assisted everybody here in the audience and hopefully the viewing public. And I appreciate, the Lapeer Tea Party appreciates everybody's attendance to this issue. And we thank you for that. And I hope to continue this in the future. So all you people who have participated, you'll be in touch with me, and I'll be in touch with you, and thank you very much. With that said, we're going on to very little. I'm just going to summarize what we're going to do next is our business meeting, which is November 10th, and we will discuss how we're going to proceed, hopefully post-election, and we'll see what happens. So then we'll move on to the closing prayer, and Carol, I'll ask you to come up.
Bill Gavette had an emergency and had to leave early, so keep him in your prayers. I also, before I say the prayer, have these timely yard signs if anybody wants one. I brought 10 of them with me. They're free. Back the blue. Father, we appreciate hearing from all of the speakers that participated with us tonight, as well as those attending here and those viewing on the live stream. We are grateful for the voting privilege we have. We do not take it for granted. Please guide our hearts and our minds.